Yes, I call it informed consent and ethics, clinical care practice. And it's very much aimed at improving patient care and patient safety. But you'll see the golden thread that runs through this presentation is really aimed at ethical conduct as well. I will go through quite quickly certain sections of the work. Others I will take more time to explain to you. And then we'll try and get as much time together once the formal presentation has been completed, so that you could engage with me by asking questions and share with me what you may have experienced in practice as well. I have as much to learn from you as you may think that you may learn from me this evening. And that's why I'll always welcome an engagement with you. You see, the concept of informed consent is encountered in medical law and ethics. And it's founded on the principle that it is wrong to provide medical treatment without first getting the patient to consent. We have made a change in South Africa in 1994. You'll see at the bottom of the slide the case of Castell versus de Greef, which I will discuss with you. But before that, just in brief, what happened was the doctors, the nurses, they controlled the relationship between the patient and I'll call them healthcare practitioners. That's a general term for doctors, specialists, as well as your nurses, and also the allied industries such as occupational therapists, physios, psychologists, etc., then very much form part of the healthcare practitioners. Now, I make the point as well that if you do not obtain informed consent from the patient, your conduct could be deemed to be unlawful, notwithstanding the fact that you have all the good intentions in the world to heal and to cure the patient. And the reason for that is if you do not get the necessary consent, your action could be viewed as criminal action or civil action, and you could be charged criminally, or you could be sued civilly. So, and where it stems from is the law prohibits the infringing of another's physical integrity, and I also dare to say that it could also their mental integrity as well. The only exception to the general rule that you need to get informed consent before you can treat a patient is in an emergency situation where the patient is unable, due to his or her physical condition, unable to consent. And there I make the point that it could solicit criminal as well as civil sanction. And then I'll discuss with you as an introduction the case of Castell versus de Greef, and I'm going to come back to this particular case and why the law changed in South Africa. This is the case. Yes.
If you could try and make your slides to full screen. I'm not sure if.
Let me just have a look. You asked me a very good question now.
You can just take your mouse cursor down to the bottom. I'll direct you.
Okay, to the bottom.
I mean to the lower border of your slides.
The lower bottom.
Yeah,
Okay.
where you are. Yes, Prof. I see your mouse slightly down again, slightly down. Yeah, then to your right slowly.
Slowly to the right.
Yeah, go again.
Okay.
Go again, Prof. Go
Yes.
again. The last one. Yes, that one. Yes,
That
thanks,
one.
Prof. Yes.
Okay, slideshow.
Yes.
Okay, is that better? Thank you very much for the coach. Thank you for the coaching I received there, Doc.
Thank
I've
you.
learned something now to look there. Okay, so you can see the High Court in Cape Town in the Castell versus de Grief case changed the face of what I call the legal landscape in South Africa. For the first time, they introduced to South Africa the principle which emanated, it's an Australian concept, and which was introduced in South Africa and has now become law. And it works as follows, that it accords with the fundamental right of an individual's autonomy and self-determination. And I'll take you through this, but at one stage, how the law worked in South Africa is that a doctor could, if the doctor deemed it necessary that he or she should act in the best interests of the patient, they could act without getting the necessary consent. That has since changed with this Castell's case, and what is respected now is patient autonomy and the right to self-determination. In other words, you have to share with the patient all the risks, et cetera, that accompany the treatment that the patient will receive. And the patient can then decide whether or not the patient wants to undergo that treatment that is being prescribed by the healthcare practitioner. The concept of paternalism is the concept that applied to South Africa before the case of Castell versus de Grief, and that is the healthcare practitioners adopted a paternalistic strategy. They would, like I said, prescribe what treatment the patient should receive, notwithstanding the fact that the patient may not want to undergo that treatment, but because of paternalism, the patient succumbed then to the treatment of the healthcare practitioner. Then we have a situation that, I say, the paternalism that once held sway involved the belief. I just want to take that and move that across. Yes. I'll move that across there. Yes, during the era of paternalism, health practitioners were not really expected to apprise the patient of the serious risks involved in an operational treatment. And that was illustrated in a couple of cases in South Africa, more in particular the Stoffberg versus Elliott matter, in which the penis of a patient was amputated. What the doctors did there, they would simply suggest to the patient that that unless the treatment was given, the patient's condition could worsen and it could be fatal in the end. There's another case of the Rumpel versus Botha, where the fracture to the pelvis consequential to electroshock therapy. There were serious burns that developed from that, and it's a matter of the doctors did not face the possibility of criminal or civil sanction as they are facing today. There you have another case of disfigurement, cosmetic changes, and necrosis, flowing from the radiological treatment for cancer, Estreisen versus the administrator of Natal, or administrator for Transvaal. What had to be disclosed to the patient was there was no need to meticulously point out to the patient what the complications are, nor was there a duty on healthcare practitioners to mention to the patient details regarding the risk of complications. That was very, very serious. And the fundamental change that has ensued after the case of Castell versus de Greef, you have to, it's imperative on a healthcare practitioner today to apprise the patient with all the risks, complications, implications that may result from the treatment that the patient will undergo. Here is the facts in the Richter case, where a young married woman injured her coccyx after a fall. An experienced neurosurgeon who attended to her gave her an injection known as Fennelbrock. You are more familiar than what I am as a lawyer of the lower sacral nerves, resulting in her losing control of her bowel and bladder, loss of sexual feeling, and loss of power in the right leg and foot. And one of the grounds of negligence relied on by the lawyers who represented the patient then is that the doctor had been negligent in failing to warn her of the possibility of these consequences. And the court found that in certain circumstances, take note, certain circumstances. So there was not an absolute prohibition then by not telling the patient what are the risks, etc., etc. Today, it is so that in all situations, in all circumstances, the patient must be warned against possible risks attached to the proposed procedure. If you don't, it's a matter of you have not then obtained the informed consent of the patient, and for that reason, you would be held liable criminally or also civilly for failure to obtain the necessary informed consent. Okay. And what happened there in that particular era, before the Castell versus de Greef case, the conduct of the healthcare practitioner was measured against the standard of a reasonable doctor. And you'll see when we discuss the Castell versus de Greef matter, now the conduct is measured against the reasonable patient standard now. What should be what should be told to the patient when you discuss what are the risk implications, etc., etc. You can see at the bottom there in red, then the Castell versus de Greef matter changed that by introducing the doctrine of informed consent in South Africa. And what the court did was to introduce the doctrine and shift from the paternalism to the patient autonomy, which I explained to you earlier, where the patient has a right to self-determination to decide after they have been apprised of the necessary risks, etc., whether they want to undergo the treatment that is prescribed. And so now that I've given you a short introduction, we're going to look now at what is informed consent, what is the nature and scope of informed consent, what are the legal and ethical requirements for informed consent, how does the informed consent operate in the healthcare practitioner-client relationship, and what are the barriers to informed consent in South Africa. I've taken out the slide dealing with COVID-19 era because we are no longer governed by the Disaster Management Act. And so I have taken out 2 or 3 slides there. Now, this is a definition that are compiled on what is informed consent. Just take note, it's a process whereby a healthcare practitioner obtains permission from a patient to undergo healthcare treatment, the patient having been provided with full knowledge of the possible risk and consequences that the procedure or treatment to be given may pose to the patient. Okay, I think I've explained it during the introduction phase already, that there is a duty, an obligation on the healthcare practitioner, including nurses, as I said, nurses, doctors, specialists also, to apprise the patient of the risk and the consequences that the procedure or treatment to be given may pose to the patient. And the term informed consent places emphasis on the patient's rights to be fully apprised of any treatment or procedure. And this includes all the information regarding his or her condition. Very important. There's a duty then on the healthcare practitioner to tell the patient after the diagnosis had been made, what is the condition of the patient? What plans of treatment are envisaged for the patient? What risk, implications, and complications does the treatment involve? And the possible consequences and costs involved. That's important. What consequences are there? And clinicians should then, from a medical perspective, inform the patient. Also, if you're in private practice or so, what are the costs, possible costs involved in the future treatment that the patient has to undergo? And I make the point here that it's only when all that is given to the patient that he could make or she could make an informed decision whether he or she chooses to go ahead and communicate his willingness to undergo the medical treatment or not. How much detail do you have to give? You don't have to give a lecture that lasts for 5-10 hours or something like it, but you must, in a nutshell, and with a clear understanding, inform the patient of the implications, etc., etc. So let's move on to the next slide. The typical consent form that healthcare practitioners use may encompass a lot of the terms and conditions which are contained in this example of a consent form. Firstly, as you can see, the condition, what is the condition of the patient as found by the healthcare practitioner? What procedure will be adopted? What is the purpose of the procedure? What's the potential benefit of the procedure? Other possible treatments that might be used instead of the procedure. And then what's important is the substantial and significant risk and possible side effects. Side effects. Now, we're going to look at the aspect of the patient who never, the nurses never obtained the informed consent of the patient who is suffering from TB, and then he developed deafness of the ear, but we'll discuss that a little bit later. Possible need for blood and blood products. And it must be made clear that there must be a clause in there to say that the patient understands the condition that was explained to the patient. He was also made aware that during the course of the operation and medical treatment, there may be unforeseen conditions which necessitates a different procedure. I'll illustrate that as follows. Let's say that a surgeon is busy performing an operation, and he comes across possibly a possible growth also, and he believes that it is necessary, without being invasive, but it is necessary that he or she removes those growths. Now, by including that in the terms and conditions of the informed consent, you consent to the surgeon to go away from the primary aim of the operation if he or she so discovers, and it could be very adverse to the patient if he does not remove the growth, for example. So he's free then to do so. You can't, in theatre now, wake up the patient and say, wakey, wakey, I've discovered this, can I go ahead and do the following procedure also? There's no time for that, and the patient is anaesthetized, so you would receive prior informed consent by informing the patient of the possibility, if should this arise. Although the procedure is generally without risk, if you foresee the possibility of risk, even if you foresee the possibility of death, you need to explain that to the patient. Also, in your informed consent, you would insert there that no promises were made about the outcome of the procedure. A doctor, a specialist, or a nurse who is so unwise that they guarantee a successful outcome may find themselves in the end in trouble. If you guarantee the result and the result does not arrive, then it's a matter of there may be a civil suit pending against the hospital if you're working in a public hospital, or in a private setup against the surgeon or against the nurses who work in the hospital, or for that matter, the doctor. And then you would also include then a clause to say that you as the healthcare practitioner is satisfied that, or the patient would rather sign this, the patient is satisfied with the explanations that the patient had received, and the patient was given an opportunity to ask questions, and the questions were satisfactorily answered, and that the patient understands and reaffirms there are risks and substantial and serious harm that may ensue from an operation of that nature. And then the patient is given the form. The patient can take his or her time before they sign, and they then acknowledge that they have read and understand the consent information, including the procedural fact sheet provided, and that they accept the risk, and they sign that. That's quite important. I also inserted a section here in consent in terms of the Children's Act. Then in terms of section 129 of the Act, a child of 12 years or older who possesses the necessary maturity and who can understand the benefits, risks, social and other implications of the treatment may consent to medical treatment. But if the treatment involves a surgical procedure, then what will have to happen is the parents must still assist the patient by signing a certain document. It's in terms of Regulation 48.1, which was published in the Government Gazette in 2010. It's a pre-printed form, Form 34. Now, I don't know if you're familiar with it. When we exchange ideas later, please share with us if you've encountered that in practice. A pre-printed Form 34 or something similar before surgery is conducted by the persons, the healthcare practitioners, whether it's a surgeon or a doctor performing such operation, or by a representative of the institution, and that form must be completed and must be signed by the surgeon, the child, and parents assisting the child. So although the child of 12 or older can consent to medical treatment, this is an exception where there's an operation to be performed, that this Form 34 has to be completed and signed by the surgeon, the child, as well as the patient parents. Okay, so that we have covered. The next aspect that I'm going to deal with is the nature and scope of informed consent. And I said to you that there is a golden thread throughout this presentation that deals with ethics. And I make the point here that it is anchored in the ethical principle of respect for autonomy, respect for another person's body. You cannot just touch a person's body by way of medical treatment or a physical examination before the treatment. But in order to make a diagnosis, you cannot do that. You need to respect the autonomy of someone else's body, and you have to inform the patient that what you intend doing, and the patient will then agree that you may carry on in trying to make a diagnosis by doing an examination, and that is called informed consent. Likewise, if you're treating a patient, if you have to give the patient an injection, an X-ray that needs to be taken, a drip that needs to be put on a patient, you need to tell the patient what you are doing and obtain the patient's consent, and that is part and parcel of the ethical principle of respect for autonomy. And foundational to this is the informed consent. The idea that flows from here is that every patient has a right to decide what can be done to his or her own body. An interesting phenomena that has reared its head out in South Africa, and I think more and more we're going to have the discussion on euthanasia. I'm busy writing an article on that at the moment, and I think that one of these days we may even engage in a public lecture one of my fellow academics at the university and I, where we would invite people to have a discussion with us on the validity of euthanasia. At the moment, it's outlawed in the country. Whether we should move, like countries such as Canada, Germany, New Zealand quite recently moved in that direction, that euthanasia was legitimized in those countries. And you can see that informed consent is entrenched in many national, international statutes, ethical codes, including those in South Africa. In terms of our constitution, as part and parcel of the constitutional rights, which we encounter in Chapter 2 of the Constitution, the right to bodily and psychological integrity. Section 12, the bodily well-being and not to be subjected to medical or scientific experiments without their informed consent. And then, as I said, without repeating myself, but if you do not obtain the necessary consent and you start treating a patient, the perpetrator may be charged with assault, and also there could be a potential civil suit brought against the healthcare practitioner. I also said to you earlier on that an exception to the rule here is in an emergency situation where a patient is unable to consent. Also where it is clear from the discussion that the healthcare practitioner had with the patient, and the patient consents to the treatment also, and the healthcare practitioner commences the treatment, then it's a matter of, it's just a Latin word for volenti fit non inuria, which means you consent to any harm that may ensue from that particular treatment. That's also an exception to the rule, like emergency, and you cannot be criminally or civilly liable then if you receive the necessary informed consent from the patient. And that you would, it would be gleaned from the informed consent form that that the patient signs, and you could use that in evidence to escape liability in the event of the healthcare practitioner being sued or criminally charged. That will provide proof that the necessary consent was obtained. But before informed consent can be said to have been obtained and that it is effective, 5 requirements must first be met. The injured party must have had capacity when consenting. Person who is unconscious or in a state where he does not, or she does not really know what is going on around them, they do not have the capacity to consent. The injured party must have full appreciation of the risk of harm. It must be explained to them in such a way that they appreciate the risk of harm. And here it is a matter of, I know medical people, as with legal people, use a foreign language to the normal man in the street also. We're very fond in law to use legalese, and I'm sure when specialists especially also, they don't often find it easy to explain to the patients in layman's language what the risk of harm may be in the procedure to be used also. But here The Consumer Protection Act prescribes that the language to be used must be in a language that is understood by the reasonable average reader of a document. Also make sure that if the patient does not understand you and will not be able to appreciate the risk unless it is explained because of maybe a language barrier, one must then make use of the services of an interpreter. The consent must be given freely and voluntarily. What does that mean? They must sign freely. You must not force them to sign, because if you force them to sign, then it's a matter of it is not being given the consent freely and voluntarily. And then the consent should not have been given for any illegal purpose. That speaks for itself. And then the consent must still be in place when the conduct complained against happens. Yes, here's the Castell case that I said I'll come back to. It's a plastic surgeon after a double vasectomy, and then also plastic surgery that was given by the plastic surgeon. She developed a necrosis of one of her nipples, and the patient claimed that had she known of the inherent risks of the procedure, she would not have consented to undergo the procedure. The plastic surgeon refuted this by claiming that he apprised her of the inherent risk of a very complex procedure, and she understood. He also produced notes in the court, and I'm going to suggest to you when we get to that particular section why you should keep particular notes once you apprise the patient of any complications, any risk, by noting it down that you have in fact discussed it with her. That is evidence that you can keep in the event of the patient then afterwards crying foul and suggesting that you never apprise the patient of such risk of the complex procedure or so. And the court found that informed consent was obtained in this particular case, and it was accepted that it was a defense in law, but provided that the following tests need to be passed. The consenting party must have acknowledged and been aware of the nature and extent of the harm or risk, which obviously the healthcare practitioner must explain to the patient. The consenting party must have appreciated and understood the nature. It must have been explained to them in clear language, in a language they would understand, and the patient must have consented to the harm. The consent must be comprehensive. That is, it extends to the entire transaction, inclusive of all the consequences, not consequences in isolation, but all the complications, all the risk that may be encountered by the patient. And this just carries on there. In order to establish whether risks are material, the judge in that particular case said a risk being material, if it's in the circumstances of a particular case, a reasonable person in the patient's position, if warned of that risk, would have likely to have attached significance to it. They would have understood that to mean there is a material risk involved in the procedure where it could lead to harm. And then I use another example in a case of Aldridge. It was this case went to the Supreme Court of Appeal, and the plaintiff in this matter was advised that the patient should undergo a femoral bypass procedure, and the plaintiff signed a consent form in which it was noted that the plaintiff consented to undergo this femoral bypass operation, accessing the femoral artery. That's the procedure which I, in my own words, summed up here, through an incision in the upper leg and grafting another vein in that area. But then it turned out to be not a femoral bypass operation, but the patient received a iliac biofemoral bypass, which is a different procedure. And then what happened is the patient obviously sued the surgeon in that particular matter, and the court quo, that is the court where the trial took place, found that the defendant had failed to diagnose and explain the dual pathology. But on appeal, this was reversed by the Supreme Court of Appeal, as you can see. Court found that it was so close the type of procedure that the plaintiff underwent, and for that reason, the court found that the surgeon was not liable, and he was absolved from any liability. Next, you can see the Health Professions Council of South Africa places a duty on the healthcare practitioner. What information should be given to the patient in order to arrive at informed consent. And you'll see there I concentrate on Rule 27A and G of the Health Professions Council of South Africa, ethical rules of conduct. The practitioner must explain to the patient the benefits, loss, consequences, etc., of a procedure. And then the general ethical guidelines for healthcare practitioners are inter alia that given the patients the information they ask for, so you must give the patient the information that the patient asked for. And all the treatment, the prognosis, it must be given in a language, as I said to you earlier, that the patient would understand, and refrain from withholding any information from the patient. Tell the patient, disclose all the information so that you could not have a backlash afterwards where the patient says, but there was only sketchy information given to the patient. And if that is the position, informed consent could never have been reached. It can only be reached if all the information is disclosed to the patient. And then you have the National Health Act, also provides for information to be given to the patient, which includes all the benefits, risk, costs, consequences, etc., etc. There is what we call therapeutic privilege, and that is if the information that is going to be disclosed to the patient will move the patient to perhaps commit suicide or cause harm to himself or herself, then you don't have to disclose that to the patient, but at least disclose it to a family member or so. Now, you may ask me, but what about the breach of confidentiality if you involve a family member also. Under those circumstances, the law will exonerate a practitioner who calls in a family member and disclose that to him or her instead of the patient who is a perhaps a vulnerable type of person. Okay, I've discussed that with you already, the emergency situation. I'll also explain to you the Consumer Protection Act, where you have to explain that in plain language. This is the aspect that I dealt with. I just want to move this, that I dealt with quite recently. And there was a patient who was admitted to one of the hospitals, public hospitals, and he suffered from tuberculosis, and also he was treated for HIV. Now, the medication that was used here was kanamycin, which has a toxic side effect on the cranial nerve of the patient. And this resulted in partial, reversible, or irreversible, could be reversible or irreversible, bilateral loss of hearing, or a loss of balance, or both, tinnitus, and you know this better than what I do, or vertigo, may or may not be experienced. But in this particular case, Vuzi, I'll call him Vuzi, not his real name, but while he was at the hospital, he started complaining to the nurses and doctors that his hearing ability was rapidly deteriorating. At first, they laughed at him and suggested that he should go home and enjoy all the pleasures of life. And his condition worsened where he picked up a zinging noise, and he complained to the nurses and the doctors. And after weeks of complaints and persistence, he was then referred to the audiological testing unit at the hospital, and then he was informed that the progressive loss of hearing was caused by the treatment regime he had been placed on. And there was also an opinion that was expressed that had this been picked up earlier, had they listened to him earlier, then his condition would not have deteriorated to such an extent that he had a loss or a total loss of hearing. And he was never warned by any staff member why he was continued being treated with the same regime. He told them, they treated him with this kanamycin, with the same regime. They didn't terminate it, nor did they look for a side effect or another form of treatment also. And ultimately, the side effect of this kanamycin then deprived him of hearing. One of the heads of damages that was claimed here is the cochlear implant, and at huge expense. So that could have been prevented through the evidence that was received by expert opinion. Various experts gave their reports and so on and so on, and it cost the MEC in the end quite a substantial amount of money. Now, barriers to informed consent, we're doing quite well. I'm nearing the end of the slide presentation. We can then get into the question and answer session, but just have a look. Question may be asked, has informed consent successfully been adopted as a practice in the South African healthcare profession? If not, what are the barriers or obstacles encountered in practices around the country? Now, there have been studies that have been done. I've read several articles also. People, including nurses, doctors, surgeons, took part in this survey. And the opinion that was reached is as follows, that it has not been successfully implemented in South Africa, notwithstanding practitioners being apprised of the reasons why they should receive informed consent and respect in that way patient autonomy, but nevertheless it has not been successful. And we're going to see now over the page on the next slide possibilities why it has not worked in South Africa. And the following was the survey in the ranking order. Language difficulties, 87%. Time constraints. If you have to sit down with the patient and explain to the patient what are the complications, risks, etc., 86%. Some people complain about a workload. They have too much as it is to do. They cannot possibly sit with all the patients and reach informed consent before the treatment is given. And remember, informed consent is given on a continuous, it's a continuous process. A patient may be admitted to the ward, stabilize the condition. He or she is can comprehend what is going on around them. So if you, like I said earlier, the tablets that you give or medication that you give, you have to receive the informed consent of that patient. That's not a blanket informed consent that he or she consents to all the treatment. Every phase of the treatment, you give him an injection or her injection, you have to tell them what is it, are there side effects, etc., etc. And for that reason, one of the reasons given here why informed consent may not have been embraced is because of the workload. Lack of medical education. Patients, unless it is explained to them in simple language that they can clearly understand, then it's a matter of you're not going to get informed consent. Lack of admin support, interpreters, cultural barriers between the various cultural groups, illiteracy and language, 79%, and medical paternalism. In other words, yeah, the doctors or certain other healthcare practitioners still embrace the concept of paternalism. They know better than what the patient knows, and for that reason, they cling to the old paternalism principle. Also give some handy hints here what to do when you try and get informed consent. Encourage patients to be part of the decision making. Explain to them whatever. If the patient were to say to you, whatever you think, doc or sister, if it is a nurse or so that is looking at informed consent and trying to achieve that, they may very well say, whatever you think is best, that's all right with me. But you need to go a bit further and tell them, no, the decision doesn't rest with you, the decision rests with the patient. And they the ones who, after you've explained to them the risk, etc., they will then give their consent, and that would be informed consent. And the healthcare practitioner should adopt a listening ear, sharing approach instead of dominating the decision-making process. That speaks for itself. Let them express their opinion. Avoid withholding possible side effects. Tell the patient, rather tell the patient than keep quiet about certain complications or risks that you are familiar with and may be consequential to the treatment of the patient. Check with the patient if the patient understands. I've explained to you now. I saw that you were listening to me. Did you understand what I was saying to you? Ask the probing questions, and in that way you can then detect whether the patient understood what you said to the patient. Minimize the risk of miscommunication by making use of interpreters, as I said earlier on. That's one of the drawbacks that practitioners don't always understand. They cannot communicate properly because the patient may be from a different cultural group. There could be the language barrier, etc., etc. To overcome that, you need to make use of the services of a interpreter. And then you need to respect the patient's right to autonomy. And what is important is this, and please, you that work in the hospitals and so on, you need to take time in making notes. What notes would you make that will serve as evidence ultimately if this matter goes to court? And that is the following: date and time of the consultation. What was the patient's frame of mind at the time when you explained to the patient and apprised the patient of the risks, complications, implications of the procedure to be adopted or the treatment to be given? Who accompanied the patient? Sometimes it's important that when, for example, you need to inform the patient now of the seriousness of the patient's condition. And I've heard from many people that when the news was dealt to them that they have been diagnosed with cancer, maybe a stage 4 or so, they go blank. They can't remember anything what the doctor or oncologist had informed them. And I would suggest then, in those circumstances, it would be far better if the patient was accompanied by someone else to assist them in that critical moment when the news is being given to them and you need the informed consent. The diagnosis and prognosis of the patient and details of the options and risks must be explained to them. And you cannot explain to them if they don't have the necessary assistance through a family member or so, which could try and calm them down. The patient can't calm the patient down. Any other information you need to share with them. And you may ask me the question, can a junior surgeon explain to the patient the risks, etc., etc., or can you use an administrative officer to explain if you were to work for a doctor and the receptionist, can they explain to the patient what are the risks and so on and so on? The answer is simply no. It must be the person who is going to provide the treatment, is going to perform the operation, etc., etc. That person is tasked with explaining to the patient in order to get informed consent. And the point I'm making here is, and I said it early on, there's no use writing up a thesis. That's not required, but there must be sufficient detail given to the patient for the patient to make an informed choice whether the patient wants to undergo the treatment that is being prescribed. And then there's just a list of sources that are consulted as well, background reading, a list of sources, including Peter Carstens. He was my promoter at when I did my doctoral thesis at the Pretoria University. There's a Sainer medical malpractice. He's a top advocate. Dutton as well is a advocate in KwaZulu-Natal. Then McCoy Mason is a legend in South Africa who's written many articles and published books. So that then ends the slide presentation. I'm going to stop sharing now. Thank you very much there, Dr. Mawela.
Hey, Prof, that was a very loaded presentation. Yeah, you know, it's quite empowering. You know, these are things we hope to go through part of, firstly, our undergraduate training, and hopefully, you know, on and on goes. And I saw as well that on your barriers, you've made of medical education is one of the key barriers. And yeah, we are very thankful to have you this evening. Colleagues, I do know my to grasp something from this particular topic. For now, I just want to engage Prof a bit, and then I'll allow some of you to raise your hands at the later stage. Prof, I have a number of questions, and then maybe they are based as well on what people have put on the Q&A. Firstly, now in terms of informed consent, can it be verbal, written, or even telephonic? And what are some of the weaknesses or requirements for either of these three modes? For example, you have an unconscious person who needs urgent care. Can you get a telephonic call from a loved one, or, you know, and can a verbal consent be reduced to writing in the patient's notes that you know, everything has been explained, that the patient is okay, you know? Yeah, maybe you can give us some guidance there. Thanks, Prof.
Okay, thank you very much for the question. Firstly, when one apprises them of the complications, risk, etc., that can all be done verbally. And remember what I said early on, it is preferable that it must be so explained that the patient grasps exactly what the doctor or the surgeon or the nurse conveys to the patient. But it has to be ultimately documented as well. If you want to get the patient to sign, it is important that you get the patient to sign. That is perfect evidence in the end. And remember, I often say that to the legal practitioners, every client is a potential enemy. And likewise, every patient could be a potential enemy. When the going's good, you're the best doctor in the world, the best nurse. I've never, ever seen a better nurse in my time. But then something goes awry. And remember, medicine is not an exact science. And for that reason, they turn on you so quickly. And that is why I would suggest then that once you have gone through all the risks, etc., that you've explained that accompanies the procedure, let them sign. And they confirm then through their signature that their rights have been explained to them.
Yes, yes. So eventually, ultimately, it must be written down. I mean, and we
Yes.
need to get patient consent through a signature. Now,
Yes.
maybe let's
You
get
could,
into,
sorry, Doc. You
yes.
could also maybe encourage in the different wards where nurses encounter patients that they apprise of risks, etc., etc. Draw up a short informed consent form that contains the necessary conditions, etc., etc., and the terms. The patient knows and comprehends what was explained to them in very simple language. You can draw up those documents and get the patient to sign that.
Superb, superb, Prof. Thanks for that. So there was a number of questions around minors. Minors, you know, they're less than 12 years and so on. So I'm going to try and cluster them, you know.
Yes.
So one of the questions was, how do we work with a minor who is a parent? So can a minor who is a parent give consent on behalf of their child in this instance, but the parent is a minor, right? And then you know, when it comes to minors above, okay, maybe let's respond to that, Prof, because I think if I cluster them, it might be a problem.
Okay, let's use the following example. Let's say that the patient is 11 years of age and she's given birth to a child.
Yes.
Is that the scenario that you envisage?
That's exactly, yeah.
And then let's say the child is the patient, the baby is the patient.
Yes.
Now, it may be a very complicated. Does the 11-year-old, it may be a complicated procedure, does the 11-year-old really have the necessary maturity? There, remember what the law says, it must be 12 years or up, 12 years and older. Let's use the example that the patient is in fact 12 years, as the law prescribes. Generally speaking, the patient could then consent to whatever operation or treatment the patient would undergo. Now we're dealing with, can that patient consent on behalf of the child? Now, if the patient, although 12 years of age, is not in a position to comprehend the implications or seriousness of the procedure that has to be adopted in that case, I would suggest that the 12-year-old would not have the necessary capacity to consent to the procedure. The parents of the, or grandparents of that little baby who has to undergo that procedure, they must be called and it must be explained to them so that they can consent to the operation or the procedure.
Hey, Prof. And then how do we test this maturity for 11-year-old or even 12-year-old? I mean, what guidance can you give to the professionals?
Well, you know, if you engage in a conversation with them, you can clearly see that, do they really understand? And you can probe that as well. Have you ever heard of this type of procedure? Have you ever heard that there is a risk? This is the risk. And if the questions, the answers continue to be no, 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 also clearly that patient is not of a mature age to be able to consent to the treatment of the minor child. And then in that way, you can deduce from the inability to answer certain questions. You should rather than get the grandparents to come and consent to the procedure.
So yeah, and it's a follow-up because there was a series of questions around this, Prof. So let's say then you deem her a little matured for yeah, she's matured and she wants a family planning, you know, injection.
Yes.
And the parent objects. Whose consent do we go with?
Remember, a 12-year-old or older, by law, they can choose whether they want the childbirth, whatever they're going to have. Even if the parents don't consent, you must listen to the child. The child, in terms of the law, is old enough to make that informed choice.
Oh, yeah. Hey, you know, health.
That's a very controversial one. I know, I'm aware.
Yeah.
But remember what the law says. And the child is matured enough. The child, in terms of the law, can consent, notwithstanding the fact that the parents are against, you know, necessary precautions being taken against potential pregnancy also.
Hey, yeah. So, yeah, I'm changing gears now to a separate topic. Where you have a mentally ill patient who's admitted under voluntary care, but now they need to go for surgery. You know, can they refuse treatment? Can a mentally ill person admitted under voluntary care, so you know, it was not forced or anything, can they refuse treatment? Can that patient refuse treatment?
If a patient through mental incapacity cannot consent, someone else must consent on behalf of the patient who is mentally challenged. It could be a family member. If there's no family member around, the administrator of the hospital, if it is in the best interest of that mentally challenged person. And consent must be obtained before the procedure is adopted by the surgeon or the doctor or so. Someone else can consent on behalf of the mentally challenged patient, and it could be the administrator of the hospital in the event of family members not being able to come and consent.
And Prof, how far, let's say the family, so can it, let's look at something like a tubal ligation, which is permanent in terms of family planning. Can a secondary person take that decision on behalf of the mental health patient?
If the patient cannot consent and someone else is expected to consent, and it is necessary, then of course someone else could consent on behalf of the patient. Is it in the primary question that needs to be answered is in the interest of the patient?
And is the parent the best person to decide that interest? Because
it's a difficult one. Do the patient actually live with the parents? The patients or the parents understand the child, understands the condition that the child is in also, and they may be in the best position to consent, or is the patient in a let's say that the patient is in, I hate to use the name institution, I can't think of another name, a haven for mentally challenged persons, then it's a matter of, you could get the head of that place where the mentally challenged patient finds himself every day. They know the patient, and perhaps they can come and give the necessary consent. But ultimately, if there's no one else, then the administrator of the hospital could consent.
Chip in, yeah. So, Prof, what is wrong with the health worker knows best? And I'm asking this because there's a number of questions which were posed to saying, so who protects the health worker when someone refuses treatment and there is a bad outcome? How does that work? Is the health worker still liable if treatment is refused and there's a very bad outcome because of that?
That's also a very, very good question. So despite all the good efforts in the world that the nursing fraternity who's taking care of the patient, or a doctor who takes care of the patient, or a surgeon also, patient does not want to give their cooperation. You cannot force the patient to subject themselves to that procedure or that treatment. As long as one covers yourself by making these necessary notes and say, this is what I have done on numerous occasions. I requested the patient to cooperate. Notwithstanding talking to the patient and advising the patient is disinterested. What more can you do there? And if something adverse happens to the patient, you cannot tie the patient to the bed and start the necessary procedure or the treatment. That would be an invasion of the of patient autonomy.
So
I don't know if I've answered that.
No. I think it's very clear, but obviously we are always cautious to say we don't want to find ourselves on the wrong side, because maybe you can always be judged that maybe you didn't give enough information, because how much information is enough information? Maybe you didn't explore all the options in terms of getting third parties, involved. But I hope the answer is quite comprehensive. Prof.
You see, if I'm going to just extend that, amplify that, if I may, just to amplify that. Let's say that it is the poor nurse who deals with the patient, and patient clearly does not want to give cooperation. The next call, if I understood it correctly, would be to engage the doctor.
Yeah.
And if the doctor also finds the same, the resistance here, no cooperation from the patient, as long as one makes the necessary notes there, now suddenly you have two healthcare practitioners, one the nurse, one the doctor, who says the patient does not want to cooperate. You covered yourself there, notwithstanding what happens to the patient afterwards. But you cannot, and I don't want to repeat myself, you cannot force the patient to cooperate.
And Prof, who's the patient? Can a husband be regarded as a, I don't know how to ask this, as a patient? but the decisions about a health matter that affects the wife, let's say it's about a pregnancy, it's about a permanent family planning ligation, or even choice of termination of pregnancy. I mean, the obvious answer, obviously, to say is the consent is from the mother, or the wife.
Mother.
Yeah.
Yes, the woman. Yes, the female.
Is there a place for other interested parties in terms of getting consent? Yeah.
No. If the patient is the person who has the necessary capacity and understands everything, and then does not make a decision which suits the husband or so, then it's a matter of there's nothing that the husband can do. It's the patient autonomy that prevails.
Because to be honest, we get caught, in these things on a daily basis, where there's a third party, secondary party, and we really are caught to say, who do we listen to? And then there was a scenario put also as a question. The clinician was saying they are the lead clinician in a procedure, but there is a second clinician who maybe has to participate as part of this procedure. Can the lead clinician do the consent form? Would that be adequate, or all clinicians involved in that care should individually provide consent? Yeah.
Okay, that's a good question. I would emphatically say I believe it is the head clinician who's in charge of that team. He has to explain to the patient all the risks, complications, etc., etc. And don't leave it to the other, because he's the person responsible for the operating on that particular patient.
Okay, colleagues, we have like 4 minutes left. I see there's hands that are up. Muso, Ramati, Ezla, Ahmed. If your hand is really up, Karino Sabto, please keep them up. Otherwise, lower them if you do not have a live question to ask. Esla Ahmed, I'm gonna, are you changing? Okay, Esla is still there. Let's try. Esla, you may unmute and ask your question live. Esla Ahmed. Yes, Esla, you may unmute.
Yes, hi, how are you?
Thank you.
Good
thank you.
evening, Esla.
I just my question about the confidentiality of the patient. If the patient have a psych patient and he have suicide ideation, but he doesn't want to tell his wife. So do I have obligation, or do I can tell the wife about his condition?
Okay,
You,
so Prof, I don't know if you got
unfortunately, there was an echo where they
Yeah.
lost
So
certain part of it.
Yes, she's saying she has a psychiatry patient who is who's suicidal ideation, but the patient says she should not tell his wife that he is suicidal. Does the health worker have an obligation to disclose that to the loved ones? Yeah.
Remember, there is such a thing as doctor-patient or a psychiatrist-patient relationship, where you have to respect confidentiality. If it is a wish of the patient not to disclose the fact that the patient has suicide tendencies, I believe that you have to respect the patient's wish, but I think what one has to do at the same time is keep a watchful eye on the patient, and through therapy or so, try and discourage the patient from committing suicide. Even if you were to tell the wife ultimately, if the patient is going to do it, he's going to do it. But there is such a thing like informed consent, which forms a cornerstone of our medical law and ethics. One has to respect the confidentiality of your patient as well. And my opinion here is exactly what I expressed early on, and that is that she will have to respect the patient wish not to disclose it to the wife.
Thanks, Prof. Sipo Munyela, you may unmute. Sipo, is your hand up? Is it truly up, Sipo? Okay, I'm gonna try one last hand.
Hello.
Oh, okay, yes.
Hello, Sipo.
Yes,
Sipo.
thank you, Dr. Mawela. Thank you, Prof. I've got two questions. The first question is, can any healthcare practitioner explain a procedure to be carried out to a patient beside the one who's gonna perform it? That is my first question. And the next one is, can a private healthcare practitioner use his own consent form for a particular procedure while he's going to perform that procedure in a public facility or hospital? Thank you very much.
Okay, good question. Two good questions. Yes. The first one deals with, can any healthcare practitioner who forms part of the team and who is going to perform that procedure, let's say it's an operation or so, can any one of them explain to the patient what are the complications, risks inherent in such a operation or procedure? Or is it only the head surgeon or so who takes charge and will be performing the operation? My opinion is it is for the head practitioner to explain that and try and get informed consent from the patient. You can't get a nurse or a scrubbing nurse or so who's going to be part of that team or junior to explain that to the patient. I believe it must be the head surgeon. And that's where the accountability comes in. He's in charge. You're the captain of the ship. If anything goes wrong, then it's a matter of you accountable. And you could then explain that informed consent was given by the patient. The other one is the aspect of you have an informed consent form, which a practitioner uses in private practice. Can you just use the same form when you go into a public hospital as such? I think that certain parts of a consent form, terms and conditions, if it's applicable in both the private sphere, could be used in the public sphere if the conditions are the same. But you cannot, I would be very, very careful to use the same form. Maybe the circumstances are different also, going from a private terrain to the public terrain. You could rather modify the consent form. I hope I've answered that question.
Yes, no, that's fine, Prof. Masood Mohamdi, sorry if I didn't pronounce your name correctly. Masood?
Good evening. Thank you very much for the excellent presentation. I have a question regarding surgery and anesthesia. Does consent for surgery includes anesthesia as well? Because we know that most of the surgery won't be possible without anesthetics involved. Yes. So do patients need to give a separate consent for anesthesia or not really?
I would advise that, yes, perhaps the anesthetist should get the patient to sign a separate consent form to that of the other clinician or surgeon also. It's a very good question. I would say they are unique. They form different functions in a theatre also. Get both of them to sign different forms.
Yeah, and in practice, Prof, it's mostly one consent form from my own experience. But yeah, this is quite helpful. Yeah.
Just tell me, Dr. Mwela, in private practice, who signs there? Not private practice, in public.
Public, it's usually one consent. I don't think there's
one consent. Does that
for anesthesia and for other things? Yeah. So yeah, but colleagues, you can confirm on the chat if what I'm saying is correct, that we have one consent. And also sometimes the actual consent and the signing might be done by a nurse versus the lead surgeon. And these are things that I think we need to pay attention to and try to improve, because you know, the patient might not have enough information to cover both. Yeah, so yeah, I think on the chat most people are talking about it's one consent, mostly talking about surgery and other things. Yeah, so need to work on that. Apollo, Prof, can we take the last 5 minutes and maybe take
sure.
2 hands and then the last few? Yeah, sorry about that. Apollo, yes, you may unmute.
Yes, thank you, Prof. Can you hear me?
Yes, I can hear you, Apollo. Thank you.
Yes, in a case where a patient, where you have got a consent, but it is has got requirements. For example, for a patient who do not want blood transfusion, and then you know that that procedure will require definitely a blood transfusion, and the situation is such that not doing the procedure would compromise the patient's life. What option do you have other than saying you go in and then you risk if you get complications as a doctor, as a surgeon?
Yeah, if the patient is an adult patient and has the necessary capacity and can clearly distinguish between right and wrong, and what we deem to be right would be their wrong because they believe religiously they will not accept a blood transfusion. You cannot force that adult patient to undergo blood transfusion. If you do, notwithstanding the fact that the patient runs the risk of dying, you're going to be in trouble there. And I regret to say it, but it is an absolute fact. You cannot force the patient. It's against his will that the blood transfusion takes place, morally as well as legally, because of patient autonomy and the right to self-determination, even if it means death. But if there was a child involved, a minor child, and the parents don't want to consent to the blood transfusion, and let's say that the child is younger than 12 or so, and then it's a matter of what could happen is, if time is of the essence,
Yes.
you have to then engage the administrator of the hospital and get the administrator to make that decision, because it is in the best interest of the child. We have Section 28 of the Constitution, which clearly reads that anything to do with a child, when one acts, one has to act in the best interest of the child. If there's time on your hands, one could bring an application to the High Court. I've been involved in a matter before. What happened was we went to see the judge at his home and explained the situation. The doctor was phoned, and the doctor explained if the child does not get the necessary blood transfusion within the next hour or two, then it's a matter of the child would die. The High Court is the upper guardian of a child, and therefore the High Court has the necessary authority to then make the necessary order that a blood transfusion will be given to that child under those circumstances. But there is a clear difference, as I've explained now, between the adult and the child. I hope I've answered the question.
Yes, Prof. We just take one last hand, and then I have two more questions, and then we sort of sum it up. Karin Sapto, you are the last hand. Colleagues, apologies if I can't take all your hands. Yes, Karin Sapto.
Hi, Prof. Lerm and Dr. Mawela.
Hello, Karin.
Thank you so much for the great presentation. So I put in the comments there about the consent. Usually at least at Tygerberg, for the most part, our interns take the consent for surgical procedures, but I will definitely relay that to our department in Obs and Gynae, that, you know, the surgeon should rather take the consent. And then the anesthetist, usually with a preoperative assessment, they discuss their anesthetic plan, but the consent is usually on one consent form. And then I just have a question. Prof touched on it.
Sorry, can I just interrupt you there?
Yes, no problem.
Yes, I listened very attentively on the anesthetist side. He fills in the 1 or 2 pages. Does he sign as well?
No, as far as I've seen, they don't have a consent form. They have their anesthetic plan in like a booklet, but not a separate consent that they take from the patient.
Now, the booklet describes what exactly is going to happen and his role or her role when it comes to the anesthesia. Is that right?
No, so the booklet that they have is basically the anesthetic notes that they'll be doing the next day. But in the consent, it will just be local general anesthetic, spinal anesthetic, and that's the extent of the anesthesia.
Yeah. Why I'm asking that question, there is a bad habit that has developed among certain healthcare practitioners, where they tell the patient, here's a booklet you can read about what are the complications, risks, etc., etc. That is a dangerous practice, because I believe that a patient should be given an opportunity to ask questions. And as I explained early on, but thank you very much for sharing that with us. I just have,
sorry, Prof, I just have one question with regards to if like if you admit a patient for whether it's an elective procedure or an emergency admission, should we take a blanket consent with regards to medication? Because obviously the patient will receive IV lines and medication and things. Should there then be a blanket consent form that outlines that these things might be done during your admission? Because it would be quite cumbersome to every time if you need to do something to go, I'm going to prescribe gentamicin, do you give consent?
Yeah. Remember when I went through that form, the consent form,
Yes.
it was very clear there, in the event of blood transfusion having to take place, in the event of medication having to, then you consent to whatever is necessary under those circumstances.
Okay.
So it's a blanket, more blanket consent that is given in respect thereof.
Okay. Thank you so much, Prof.
Yes, thanks, Karin. We appreciate your question. Prof, two more things which are just general. When we get to the court of law, does the court take into account systems barriers that could have contributed to a poor consent form, informed consent process? You have presented the barriers. Those barriers exist, and they have huge implications on, the quality of the informed consent process. Are those systems issues taken into account about the particular day and what was going on in the institution, leading to certain lapses in a known procedure, which is quite common when we talk about patient safety incidences? Yeah.
The courts, with all due respects, it's a matter of they want a perfect system in place, and one cannot come with excuses that on this particular day my workload was X, Y, and Z, and for that reason my conduct should be exonerated under the circumstances due to, and they highlight the constraints that they were faced with. The courts don't.
All right, Prof. Yeah. Okay. Lastly, in the emergency unit where people deal with urgent matters, what comes first there? Because usually in the emergency unit, there's a vehicle accident, and someone needs immediate interventions, and things are done. Do they need to try and get consent for every single urgent case, or what provisions are there in the law for sometimes you are stopped as a doctor on the road. There was just an incident and you feel like you want to intervene or help, for example, how does consent come into play? And because that might limit access to care to a certain extent.
That's an excellent question. And once again, it depends on the circumstances. If the situation is so dire that one has to immediately start giving that treatment, if the patient cannot comprehend, etc., then it's a matter of emergency takes over, and one is not expected then to comply with all the requirements here. Once the patient condition has improved also, one can then, from then onwards, one can explain that to the patient and then get the necessary informed consent also. But in a situation, remember what I said earlier, emergency situation exclude that. You cannot, by law, you're not then expected to meticulously talk to the patient. There's no time here. It's more important that you stabilize the condition of the client.
Prof, I must thank you for your time. Colleagues, we can't go through all the 50 plus questions. I think we have went through half of them, and I'm so excited to see 300 and plus of you still here. It means this topic is very important to all of us. I will share your comments and questions with Prof. We will see if we can do a quick Q&A kind of response, Prof.
Yes.
And I will also share, the resources, if I'll get permission from Prof, if I can share his slides and stuff. and then we
Yes.
take it from there. But Prof,
may share.
your closing remarks so that people don't forget the take-home message.
I think thank you very much once again for inviting me.
Yes,
I think what is important here is the focus was on patient care, and patient care includes informed consent.
Yes.
And I rest my case.